Today on Bench Briefs, we're looking at a fascinating case that sits right at the crossroads of national security, immigration, and fundamental freedoms. The British Columbia Civil Liberties Association versus Canada, decided by the Federal Court of Appeal in 2026, challenges the constitutionality of a specific section of the Canada Evidence Act and raises important questions about how far the government can go when handling sensitive intelligence in immigration cases. So, what's this all about? The British Columbia Civil Liberties Association, or BCCLA, took issue with Section 38.62 of the Canada Evidence Act. This provision deals with the admissibility of certain types of evidence in proceedings related to citizenship and immigration, particularly when the Canadian Security Intelligence Service, or CSIS, is involved. CSIS is Canada's main agency responsible for national security intelligence, and it often deals with highly sensitive information. In this case, the provision was applied during exclusion and removal decisions under the Canadian Security Intelligence Service Act, essentially when the government tries to exclude or remove someone from Canada based on national security grounds. Section 38.062 controls what kind of evidence can be used in those proceedings. The BCCLA argued that this section infringes on fundamental freedoms guaranteed by Section 2 of the Canadian Charter of Rights and Freedoms. Things like freedom of expression, freedom of association, and freedom of peaceful assembly. The case came before the Federal Court of Appeal as a judicial review of the reasonableness of the decision to apply Section 38.062. The key question was whether this section of the Evidence Act aligns with the Charter's protection of fundamental freedoms, and whether the decision to use it in this context was reasonable under the law. Let's break down the legal issues a bit more. First, the court had to consider if Section 38.62 violates Section 2 of the Charter. This is significant because Section 2 protects core democratic freedoms that are essential to Canadian society. The BCCLA argued that by limiting the type of evidence that can be presented in these cases, the government was essentially restricting the ability of individuals to fully defend themselves and to participate in proceedings that affect their rights. They contended this limitation could chill those fundamental freedoms. Second, the court had to assess whether applying Section 38.062 in these immigration and citizenship proceedings was reasonable. Judicial review is a way for courts to ensure that government decisions are fair, rational, and comply with the law. The court had to balance the government's interest in protecting national security with the rights of individuals to a fair process and fundamental freedoms. In its decision, the Federal Court of Appeal examined the purpose of Section 38.062 and the context in which it operates. The provision was designed to protect sensitive intelligence information that, if disclosed, could harm national security or ongoing investigations. At the same time, the court recognized the importance of safeguarding charter rights. Ultimately, the court upheld the constitutionality of Section 38.062, finding that it did not unjustifiably infringe on fundamental freedoms under Section 2 of the Charter. The court reasoned that the provision strikes a necessary balance between protecting national security interests and respecting individual rights. It also found that the decision to apply Section 38.062 in the specific immigration and citizenship proceedings at issue was reasonable. Why does this case matter? It highlights the ongoing tension in Canadian law between national security and individual rights. As governments grapple with protecting the country from threats, they often rely on secret intelligence and special legal rules. But these measures can sometimes limit the transparency and fairness of legal processes, especially for people facing removal or exclusion from Canada. This case confirms that courts will carefully scrutinize these security-related rules to ensure they don't cross the line into unjustifiable charter infringements. It also shows that the legal system recognizes the complexity of handling sensitive intelligence information while still upholding fundamental freedoms. For lawyers, policymakers, and anyone interested in immigration law, national security, or constitutional rights, this decision is a reminder of the delicate balance that courts must maintain. It underscores the importance of procedural safeguards and judicial oversight when fundamental freedoms are at stake. Thanks for listening to Bench Briefs. Be sure to join us next time for another deep dive into an important Canadian legal decision. Until then, take care.